EMAC has had a very interesting story from the beginning. It was born out of an idea in 2014, spearheaded by the DMCA, Dubai Maritime City Authority, who went out to market, did a feasibility study about the requirements of dispute resolution specific to maritime in the region, to find out if there was a gap and if an arbitration centre would fit into this part of the world. And after 2 years of conducting the survey, the industry did come back and were very positive about an arbitration centre that could manage their needs, and essentially EMAC was established by royal decree in April of 2016, and that was the time that the statute was established and the Board of Trustees were nominated. And the Board of Trustees at the time were heavyweights in the maritime industry in the Middle East. In fact, there were 15 of them. As time went on, in November of 2016, the centre was then fully established operationally. So the secretariat were put in place, wherein I joined the company. And we then had to kick off our operations. And arbitration is not an easy service to put forward to an industry, but we started our journey in November 2016. And what we then did was we ran through a whole host of events to try and bring the name of EMAC to the industry, what we stood for, what we do to the industry. And we have just nominated our new Board of Trustees, of which there are 13 members, which will be announced after the annual board meeting at the end of this month. Again, also very influential figures from the maritime industry. Now, in terms of corporate governance, EMAC is fully independent. We manage our own finances. There's no outside influence. We are overseen by the Board of Trustees, and out of the Board of Trustees there is a subcommittee, essentially our executive committee, of which there are currently 4 members. Our executive committee provide the light touch case management support, which I'll get to in a minute. And then they oversee, obviously, how the Secretariat performs in our day-to-day functions. Part of our mandate is to bring awareness to the maritime industry, and it's got a little bit of a law focus on it. So we have these breakfast seminars, which are basically an hour long, one a month, where it's open to the entire maritime industry, completely sponsored by EMAC. And what we basically do is bring topics of a very practical nature to the industry, and we invite speakers that are experts in those topics to brief the industry. So for instance, we've had topics that look at cargo claims, look at insurance claims, look at bills of lading and how they work. We've looked at digitalization in the industry and what that means from a regulatory standpoint. We've looked at the maritime law. The UAE has a draft maritime law. So these types of seminars basically are designed to bring the community together, and it's a real community feeling that we have at these breakfast briefings, but it also gives them a platform to ask the questions that they need to ask. There's no judgments, it's completely open to the industry, and it starts that conversation. And it feels like when you're sitting in your living room and having a conversation, it's that kind of community environment that we're creating. And in that, we are showcasing EMAC's ability to engage with the maritime industry, and EMAC's ability to understand what are the hot topics and where we need to go out and find arbitrators to list on our panel directory.
So disputes can arise in any industry out of effectively contracts or out of tortious relationships. So in shipping, the main contractual disputes we see are charter party disputes, bill of lading disputes, bunker supply disputes. Basically, those are disputes arising out of the shipping contract, a contract that exists between stakeholders in the shipping industry. The other sorts of disputes that arise are disputes that arise between parties that don't have a contract in place. So for example, when two ships hit each other, or when a ship grounds and it causes disruption to some other stakeholder in the maritime industry. Those claims arise out of the tortious relationships, and therefore they also lead to disputes. Now, arbitration is generally only relevant to contractual claims. And I say generally because parties that don't have a contract can still choose to go to ad hoc arbitration. So they can say, right, we have a dispute, it happened, we never meant to contract with each other, we never meant to have a relationship with each other, but the world has got us to this situation where now you and I, or one party has a claim against the other, and even though we don't have a contract, we can agree to still go to arbitration. So arbitration can apply to all sorts of disputes, but I guess contractual arbitration, or arbitration that arises out of an agreement in a contract, is much more common.
I am not a law professional, so I can speak from a commercial perspective, and I come from a chartering background, and chartering specifically is known to be quite heavy in claims. So there are claims that your P&I insurance will cover, and there are contractual disputes that do occur in the course of business. So instead of going to litigation, arbitration is a viable solution. It's an alternative, and it's enforceable by law because of the New York Convention. And I believe there's over 150 plus countries that are signed up to the New York Convention. So you could seat a dispute here following EMAC's arbitration rules with EMAC's support services, and basically with that run through your arbitration, have an award, and then go and enforce that award in any one of the 150 plus countries. So it could be in London, for instance. In any dispute in maritime can go for arbitration. Obviously not all contracts would work in an arbitration scenario, but companies would go to arbitration if they wanted to maintain their relationship, they wanted their business dealings, they wanted to keep the case or the dispute private and confidential, because in a scenario of litigation it's public record. Whereas in arbitration, it's private, it's confidential, the parties run the process, they decide who the judge or arbitrator of their case is, and it would be someone that understands the merits of the problem. So, you know, arbitration's not the only solution. There are also lighter ways of resolving disputes like mediation, and EMAC caters for that as well. So there's arbitration and mediation, and we have different forms of arbitration as well. So it's quite a nice hybrid solution, if you can put it that way, in terms of catering to disputes in the region.
Companies can come to EMAC from wherever they wish to come, effectively. If the incident happens in UAE waters, then there is no contract between them. If we're talking about an incident, there's no contract between the parties. So they need to say, right, we need someone to help us work out how we're going to resolve this dispute. We think the best forum for that is the Emirates Maritime Arbitration Centre. So let's refer our dispute to that. Alternatively, they can be parties where one party is based in the region, or even both parties are based in the region, and then they have pre-agreed that if they have a dispute, they will refer the issue to the Emirates Maritime Arbitration Centre. So there is a degree of freedom as to when you refer a dispute to EMAC, but I think in practice you will find there will be a link or some sort of nexus to the region.
Before you go into arbitration, it needs to be decided at the inception of an agreement. So you will walk into, in this case, say a charter party, that is a standard form, where you will go to your dispute resolution clause, and you will agree from the start that in case of a dispute, a contractual dispute, we agree that we will take to arbitration instead of litigation. So it's agreed from the inception of the agreement. When the benefits of arbitration is, again, that parties can dictate the way that the process flows. So EMAC has a set of rules that are based on UNCITRAL international arbitration rules, and our rules are, it's very closely mirrored to that. But what we do is say you and I are in a dispute, okay? Instead of you giving the files to someone in your office to manage, we do that for you. And we make sure that all the parties know what's going on, that the process is followed, that it's followed up. But let's give a scenario where we say within 30 days, we agree we're going to have a hearing, and the parties decide, no, actually we're going to wait 6 months. The parties then decide that process. Now, again, in litigation, a judge may not understand the technical merits or the complexity of a case. And this is where the arbitrators are great, because the parties will agree on an arbitrator, 1 or 3, depending on what their agreement is. And those arbitrators will understand the complexity of the case. They'll understand the technical nature of the case. And they can make a decision based on the merits of the law, but also on the merits of the case. Whereas a judge that has no maritime experience will rely on experts. In terms of the cost, you could quantify it in terms of time. So the quicker you get to resolution of the case, the less time you will spend on lawyers, on the case going on all the additional fees. But it's debatable. I mean, there are many articles out there about whether it is cost effective or not cost effective. In terms of going to EMAC, it's cost effective. You pay a one-time fee that will actually be very, very, very competitive, and we will manage the administration process from A to Z. We also have great facilities. We have hearing rooms, we have access to stenographers, we have corporate deals with hotels to help. So we try where we can to make it as cost effective from a logistic point of view as possible for the parties. Basically, on shore in Dubai, you have a civil law jurisdiction. In that civil law, the courts are in Arabic. Your documents need to be in Arabic. Whereas in the DIFC and now the ADGM, so it's Abu Dhabi Global Markets and the Dubai International Financial Center, they follow a common law system. So you can, most multinational companies here are more comfortable with a common law system and want to have their dealings in English. Those two systems make it very easy for them to conduct their business.